Good morning, and welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel from Orange County. To my right, we have Judge Harris, I believe from Brevard. And to my left, we have Judge Orfinger from right here, Daytona Beach. Please make sure to turn off your cell phones, any electronic devices, so that we don't interrupt the advocates today. And a couple months back, the court changed its rules to allow 20 minutes per side on all cases, both criminal and civil. And so all of our cases today, counsel will have up to 20 minutes. If you're the appellant, please just, before you begin your argument, let me know how much time you'd like in rebuttal, and I'll do my best to dial that into the clock, and I'll also do my best to remind you when you are close to that time. And so with that, counsel for the appellant, let me know how much time you'd like in rebuttal, and we're ready when you are. Counsel, how much time would you like in rebuttal?
5 minutes, Your Honor.
Okay. Whenever you're ready, no rush.
Thank you. Good morning. May it please the court. Michael Lefferman on behalf of the appellant, Spencer ALTSCHULER. I'll focus my time this morning on the first two claims raised in the briefs, and I'll begin with the first claim. The first claim concerns whether or not the trial judge erred by denying the motion to dismiss and/or denying the motion for judgment of acquittal. And as I've argued in my briefs, the state failed to establish the essential element of recklessness in this case. The state did not establish that my client drove in a reckless manner that was likely to cause...
Counsel, isn't this case pretty close to the DePriest case?
Your Honor, I think that was the next point I was getting ready to make. Judge Morgan below acknowledged that this was an extremely close case. He said, this is pages 879 and 880 of the record, that one of the appellate issues that is critical, the one which I think the case would likely be decided, is the sufficiency of the driving pattern in this case to support a jury finding of reckless driving. And that is a real close call. I mean, there's one case that the court hung its hat on pretty much that had very similar facts, but I could see how that would go in either direction. That's the DePriest case. He later acknowledged, and this is page 743 of the record, that there is a difference between this case and the DePriest case, and I have focused on that difference in my briefs. In DePriest, the first DCA was able to find the element of recklessness, and recklessness is defined as willful or wanton conduct. Wantonness has been defined as consciousness and intentional indifference to consequences with knowledge that damage is likely to be done. The first DCA found that in DePriest because the defendant gave a recorded statement to the police, and in that recorded statement, he acknowledged that
he did it for his convenience, essentially.
He drove the wrong way for his convenience.
But counsel, I mean, don't we have an inference here? Couldn't the jury have reached the same conclusion without your client's admission that he was doing it for his convenience, based on the testimony of the other witnesses? The other witnesses said, look, he was in the other lane forever, and there was plenty of room for him to get over, and he just didn't do it.
Well, not forever, and a couple things.
Okay, half a mile at least, 45 seconds, I think one of the witnesses said, 30 to 40.
Seconds.
30 to, didn't somebody say 45?
Up to 40, I believe. 30 to 40 was the
30 to 40 seconds, half a mile, had plenty of room to get back over, didn't. Doesn't that create an inference similar to the admission in DePriest?
Here's the key difference, and I believe the key witness in this case is Karen Bellis. She's the driver that was passed. Her husband testified he wasn't paying attention the whole time. The other driver that was being passed didn't, they maybe didn't say as much either. Karen Bellis is the key witness. Page 57, this is what she says, that my client was behind her in the correct lane, the westbound lane. He then, this is her quote, seemed like he wanted to pass, kind of moved over to the center line like he was trying to look around. And then he did pass, but he wasn't going fast enough to make the pass. He actually drove next to her for a while and then ultimately got past. She
slowed down so that he could get around her.
She saw the other car coming, she honked her horn, and ultimately, before the end of the passing zone, he braked and did turn over, but the other car at that point was also swerving to avoid the collision, and that's
the testimony was the other car swerved 2 seconds before your client did.
Correct. into the westbound lane, which should have been my client's lane. So the difference between DePriest and what I just told you about Ms. Bellis' testimony is that my client was correctly in the westbound lane. He was hesitant. And I think, a point the state says in their answer brief that there's little more dangerous for a driver to do than to drive on the wrong side of the highway. Passing in Florida is legal if you are in a passing zone. Now, it may not be easy. It may not be easy for...
Counsel, the testimony, though, was that he was no longer passing in the sense that he passed the car, and then at that point, he could have easily gotten over. That's what the other witnesses said.
Again, well, one of the witnesses says, was there enough room? And his answer was, it seems like there was. I'm not sure it's crystal clear.
One of them was very, very adamant that there was room.
And again, that's why I come back to her test. This wasn't someone like DePriest, who, if he had come up on these cars in the wrong lane already and was plowing on by at a high rate of speed, and it was clear that he's only in the wrong lane, then that is someone who has made the conscious intent, just like was admitted to in DePriest, to drive in the wrong lane. My client is hesitant behind Miss Bellis to even pass at all. He's kind of peering around to see, can he pass? Again, and I come back to this, passing is legal, but it's not always easy. My client was a 19-year-old sophomore at the University of South Florida. We've all been on roads where we thought about passing or not. We've all done that. Let's peer around. Can we get around? He is showing someone who's more hesitant. He's not comfortable with what's going on. So coming back to the definitions of reckless driving, the cases the case from the 3rd DCA that I cite extensively in my brief, Luzardo, does a great explanation of many cases that have affirmed versus many cases that have found that the conduct does not amount to recklessness. This falls within the category that doesn't amount to recklessness because this is simply negligence. It's someone who, it's careless driving, and we know careless driving is insufficient, but it doesn't amount to the wantonness and the willfulness to be reckless driving because, again...
Counsel, what evidence, given our standard of review, we're not the fact finders, right? And so what evidence below was there that might have, that the jury could have decided why your client stayed in the wrong lane? I mean, in DePriest, we know. I mean,
we do know.
The defendant there admitted, hey, I did it because it was just convenient and I didn't feel like getting over, essentially, right?
Correct.
In this case, it seems to me, and I understand that you're hesitant to admit that, to agree with me on this, but it seems like there's an inference that the jury could have concluded based on the testimony that your client just stayed in the left lane for the same reason, for convenience, even though he didn't admit it. What other evidence?
Or, I think the other key there is, or he just didn't feel like he could get back over.
Well, what evidence is there of that?
Because he's showing signs of a hesitant driver. He's not just plowing down the road in the wrong lane
because he had trouble getting past or he wasn't speeding necessarily.
He peered out first. This is not someone who's displaying other signs of recklessness. She said, it seems like he wanted to pass me. It seemed like he was kind of leaning out to the center lane to see if he had enough room. Then he came up next to me. He was actually going pretty slow right next to me. I was surprised that he wasn't going fast enough to get around me. I had to slow down.
So, counsel, let's assume for a minute that is the inference that certainly the jury could have concluded that he really was being cautious, right? And so something else
wasn't acting with recklessness.
Well, at the time that he peered around the car, right? I mean, I think the question is was he acting in a reckless manner after he got past the car and could have gotten over, according to the testimony, right? That's when was he reckless at that point?
We don't know. It's just as likely that he just didn't feel he had enough room to get back over.
But if there's two conflicting inferences, right, we can't reweigh that evidence.
That's not true. If you look at every single case where the courts have upheld judgments of acquittal under these circumstances, it's the exact same thing. This court's case in Berube, where the defendant was in the right-hand lane and swerved across oncoming traffic across two lanes and caused an accident. You could say there's no other explanation other than the actions that you look at, that if he did that, that must show that he's acting reckless. But the court also said that it's consistent with someone who's simply exercising negligence or careless driving.
You're saying that this is a apparently very rare circumstance where the appellate court can be the fact finder?
No, I'm saying that absent the evidence of recklessness, this court cannot affirm my client's conviction.
But I guess that's what I'm saying is, isn't there, and I'm not trying to give you a hard time. I do think this is, it seems to me this is a close case. But I guess what I'm trying to get a straight answer from you on is, do you think there was an inference based on the testimony from the other witnesses, that your client was traveling in the wrong lane for no good reason.
It's just as likely that he just couldn't get over.
No, not just as likely, because at that point, the jury decides. If there's two possibilities based on the evidence, the jury decides which one it was, right?
No, but it's the state's burden of proof to show recklessness. And in Dupreece, they could show it because the defendant admitted that he drove in the wrong lane for the sole purpose of convenience. We do not have that in this case. We have my client.
But I guess that's my question. Isn't there an inference that the jury could have concluded your client was driving in the wrong lane based on convenience or some other illegitimate reason?
It's just as likely that my client simply felt that he couldn't get over. He was a cautious driver. He's a 19-year-old kid. It's not easy to pass. And under these facts, you just don't have recklessness.
But if two inferences are just as likely, one that cuts against your client, one that goes in your client's favor, and they're just as likely as you say, isn't it for the jury to decide which one it was?
No, well, for the motion to dismiss purpose, the state has the burden of showing a prima facie case of guilt. And absent some proof that my client was purposely staying in that lane, was doing so for convenience like Dupreece, as opposed to just didn't think that as a 19-year-old kid he could make the pass, then the state didn't meet their burden of proof for a prima facie case under the motion to dismiss standard.
Well, the law isn't that he has to be over there for convenience, is it?
The law is he has to be acting with recklessness. So the other thing I want to get to...
So is there evidence adduced at trial that would support a finding by the jury that once he passed Ms. Bellis's car, he remained in the wrong lane for half a mile, 30 to 40 seconds?
But not for recklessness purposes.
No, just answer my question.
He did remain in the lane for 30 seconds, yes.
Okay, up to half a mile.
Up to half a mile, yes.
Okay. And for what purpose?
He couldn't, it's just as likely that he couldn't get over, but just as likely that, so the state's inference that it may have been for convenience without proof of that is not enough. They have the burden.
You don't have to prove convenience. Is there evidence from which the jury could find that during that 30 to 40 seconds, half a mile, that he could have gotten over into the correct lane?
There is no evidence that a rational trier of fact could find the element of recklessness in this case.
Okay, that wasn't my question.
Well, because what you just described is not per se recklessness.
Okay, and we can debate that, but that wasn't my question. Is there evidence from which the jury could have found that in that 30 to 40 seconds, that half mile, he could have moved to the other lane and did
yes,
not?
Yes, the witnesses said that he could have gotten back over. That doesn't mean it's recklessness. Because if in his own mind, he was cautious, wasn't sure he had enough room, this is someone who's pulling out, again, a 19-year-old kid, that doesn't show recklessness. So the other point I think that's very important to look at in this case is...
Well, we don't know what was in his own mind.
Well, we don't, but okay, so let's look at all the other factors. And the other courts, many courts, look at what factors do not exist to show that there's not recklessness. This was a clear day. It's the middle of the day. It's a flat road. It is in the passing lane. There's no evidence of intoxication. There's no evidence of texting or him doing anything else that would be improper. When you look at the other cases that have affirmed, you have the Martinez case from the 3rd DCA going 70 and a 30 with a curving road, and he did pass in a no passing zone. That's easy. That's vehicular homicide. You have the House case from the 2nd DCA going through a residential neighborhood, 60 miles an hour in a 30-mile-per-hour zone. Trees blocked his views. 2nd DCA, no recklessness.
Well, counsel, look, there's a lot of cases out there that are not close calls. I agree.
Well, but no, the House case I just said, this is not as egregious as House. House was not vehicular homicide. I would ask this court to look at that. Let me repeat that. Residential neighborhood, 60 in a 30-mile-per-hour zone. Trees were blocking his views. The 2nd DCA, that's not sufficient to establish recklessness.
What you've got in this case, Mr. Offerman, I mean, Dupreece is factually as close to the facts of your case as any two cases I've seen. I mean,
but it's different.
Try to make these distinctions. But
yes.
The court in Dupreece said the jury, under those facts, can lawfully, reasonably decide that willfully and unnecessarily driving 55 for a half mile in the wrong lane, when capable of returning to the correct lane, is willful and wanton disregard. It's the jury's call. Given that that was the case law, how did the judge err in not granting the JOA?
Because he acknowledged there's a difference. The difference is what I'm pointing out. In DePriest, the defendant said he was purposely remaining in that lane.
Counsel, let's assume for a moment that we think that we concluded that there's an inference in this case that your client stayed in the wrong lane for no legitimate reason, whether it was convenience or something else, just there was no legitimate reason based on the testimony. Let's assume that for a moment. Then do we have to disagree with DePriest to rule in your favor?
No. The difference is you have an admission by the defendant in DePriest. You do not have that here. And that's the distinction. And I think Judge Morgan realizes that.
I guess what I'm asking, is there any other distinction?
Well, is there any? I come back to this.
Or should we disagree with DePriest? Maybe DePriest was wrongly decided.
I'm not asking you to do that, and I am asking you to come back to this. If Karen Bellis had said that my client approached in the eastbound lane behind her, was never once behind her, the entire time was only in the wrong lane to pass her, that would show someone who was clearly driving on the wrong lane and doing so purposefully. My client did not do that. He approached Ms. Bellis's car, he peered out to see if he could pass, and then he passed. He didn't get back in time. He later tried to get back in time. He braked, and he also tried to swerve back in before the no passing zone ended. That's indication that he's trying to get back in the right zone. He should have done it earlier, but it's no different than all of the accidents you see on the nation's highways every single day. It's not the amount of recklessness that amounts to a crime.
Counsel, you can keep going, but you have 5 minutes left.
Thank you. I do want to address the second issue because I think we talk about why would the jury have done what they did in this case. I can tell you potentially why the jury what they did in this case.
Counsel, the photograph in our record is awful difficult to see. What did the jury see?
They saw this picture. It's page 464.
Was it a black and white photo just like that?
The record does show it's a black and white photo.
Well, no, I know our record does, but it's when you look at our record, the photo in our record, it's really difficult to make out what it is.
The prosecutor indicated it was a black and white photo, so I can't dispute that. And so I can only go by what's in my record as well. Nevertheless, what's in the record is a charred body.
Well, but that's what I'm saying. When you look at it, I mean, I can't tell what that is when I look at my record.
The jury was told this is a charred body. So the prosecutor below said, I want to get this in to show the position of the body. This isn't the position of the body at the time of the accident. The victim died immediately. The car caught on fire.
I guess my question is how gruesome can it be if you can't even tell what it is?
If they were shown a photo without any indication that what's in that photo, I would agree with you, Your Honor. They're shown a photo clearly being told this is the victim's charred body. There's no question about that.
How is that any different than just telling the jury the body was charred? I mean, if you can't tell what's in the picture.
Well, so I guess I still want to focus on, was it error to come in? Was it probative of anything? And the state.
Yeah, I guess I'm going to harmless error.
You are.
Yeah.
And so let me just quickly point out, the state in its answer brief said the single photograph was relevant because Dr. Utz was
let's assume for a moment that it was an
not
error.
Probative of anything.
Let's assume for a minute it was error.
It was an error.
Why isn't it harmless? I mean, because you can't even tell what it is.
But okay, I understand you're saying that it's not clear to a normal person just walking upon this photo to know what it is, but once they are told this is a charred body, all of a sudden they now know what it is, and it's traumatizing to look at this picture of what looks like charcoal. But what it actually is a human body that's been burnt in this case, and the fire is after the accident. She didn't die as a result of the fire, and yet the jury is being presented with this traumatizing photo that, no, this isn't just what you think it is, that, charcoal next to a fireplace. This is actually a human body. So I agree with Your Honor. If they weren't told,
I think the photo is so poor that I can't even say it looks like charcoal. To me, it looks like a really bad photocopy.
Your Honor,
I looked at it for a long time, and
well, I respectfully submit to you that when you look at this photo,
464, right? Page 464?
In the context that you're told that this is a charred human body, you at that point now are going to be traumatized by this gruesome photo.
Let me make sure we're talking about the same photo. Which page are you looking at?
464.
464.
It states Exhibit 12. It came into evidence. Initially, Judge Morgan was saying all the things that I'm saying, that I don't see why it's relevant. Why do you need to tell the jury this? He ultimately says, I'll let one picture in that shows the scene with the body. This isn't the scene with the body. Once they realize that this is a charred human being, that's when it becomes traumatizing. So I understand if you didn't know initially, you may not understand what this even is. But the moment you are told this is a human being, and it's clear that this is a human, there's black soot on the sheet underneath this. There's no purpose for this to come. The state knew good and well why they wanted the jury to see this. This was a very close case for all the reasons we've just been discussing. And yet the jury somehow saw this. So I've cited to the Connor case, when it comes to harmless error, and this is the standard, the state must prove, it's their burden to prove beyond a reasonable doubt that that this in no way affected the jury's verdict. And Connor, same type of situation, the second DCA said it's impossible to say.
Counsel, you have 1 minute left.
The admission of this photo did not affect the verdict.
Well, staying on the harmless, let me ask you before you sit down. The testimony came in, I think at least 2 occasions, that there was extreme charring of the body. That testimony came in without objection. So adding the photograph, I mean, they already got the testimony.
It's one thing to hear that the body is charred. I've never seen a charred body before in my life. But the moment now you see a picture of this as a charred human being, I think we all agree that it was not probative of anything. It shouldn't have come in. So the question is there any possibility?
The evidence already came in. The testimony came in unobjected to.
The body burned, but now they're able to see it for no reason other to, why? I guess I would come back to this. Why did the state want it in? Why were they so adamant about getting this in? Because they knew that this would have an impact, maybe even just on one juror. And if this court believes that it's possible that one juror was impacted by this and that traumatized them, then we win because they can't meet their burden of showing that it didn't affect the verdict beyond a reasonable doubt. I now have 20 seconds left. I'll reserve my time.
Thanks, counsel. Counsel, whenever you're ready.
Thank you. May it please the court, my name is Charlene Matthews on behalf of the state of Florida. I respectfully argue that this is not a close case. After the appellant decided to pass and moved over into the eastbound lane, the passing lane is what we'd call it, he had ample opportunity to pass and move back into his proper lane. He stayed in the wrong lane.
Counsel, isn't it easier for someone, a witness that's in a different vehicle? Sometimes it's easier for somebody behind a vehicle to say, hey, they have plenty of room to get over, right? But the driver may not, it may be more difficult for the driver to tell how much space is there, right?
Mrs. Bellis was directly across from the appellant and then catty-cornered. There were no vehicles between Mrs. Bellis and the next vehicle ahead of her. She's the one who said that there were 6 car lengths available, the space of 6 car lengths for the appellant to pull back in. The time period, 30 to 40 seconds, it's inexplicable, but the state isn't required to prove the motive of the appellant in staying over there that long. However,
well, look, if it was, I think even your brief sort of recognized, like, look, if this was he was distracted for briefly, that kind of thing.
Yes, sir.
This wouldn't be recklessness then.
This isn't a split-second innocent
I don't know that it has to be a
error,
split second.
or even 5 or 10 seconds. It's 40 seconds traveling in a lane that's not yours, knowing that there is a certainty that oncoming traffic will appear, and lo and behold, there was the victim's car.
This case is closer than DePriest, right?
I don't believe it is, Your
Well, come
Honor.
on. DePriest happened at 1 in the morning. This was a sunny day in the middle of the day on a straight road. Come on, right?
Exactly, which gave him more of an opportunity to realize.
Well, I mean,
that there
you don't
was
think
a
that made it
vehicle.
less reckless? I mean, don't you think it's more reckless anyway? I'm not asking you to concede that this wasn't reckless. I'm saying, isn't it more reckless to do this at 1 a.m. on a dark road? Dark country road, I think DePriest said.
I think they're both incredibly reckless.
Well, no, I'm asking you which one's more reckless. I know you think they're both reckless, but I'm just asking it, is DePriest, this case closer than DePriest? Is it more reckless at 1 a.m.?
Respectfully, I think this case is not less reckless than DePriest for the following reason. Once the victim's car became visible, all the other witnesses saw the victim's car coming at the appellant. 20 full seconds elapsed. 20 seconds. That makes a difference between some hypothetical or theoretical danger that can exist.
Well, doesn't the fact that he did try to get over at the very last second, wouldn't that raise an inference that he was distracted while in that passing lane, and that he suddenly realized the car was there and tried to get over?
If he was distracted, if he, there's no evidence he was trying to kill the victim. We don't know. It's inexplicable. Some people act recklessly for inexplicable
But
reasons.
if he's simply distracted, is that reckless? For whatever reason,
You have the duty on the roadway to pay
I
attention
understand
to what your
negligence. I understand
multi-ton
careless.
vehicle is doing, Your Honor. Within,
driver, Mrs. Bella, said that she was screaming and honking her horn at him
Yes.
for 20 seconds to get his attention.
yes,
So he's simply not paying attention? In your brief, you say that she was trying to snap him back into reality. If he wasn't in reality, was he daydreaming? What do you mean snap him back into reality? Those are your words.
his actions are inexplicable.
Okay, but
that was
Hang
what
on a second.
she
What
was
did you mean
honking.
when you said you're trying to snap him back into reality?
That was the purpose of her honking, Your Honor.
Okay, so
She
he's
was trying to
daydreaming.
get
He's not
his
paying
attention.
He's not paying attention. Is that
She
reckless?
was trying to get his attention.
Okay.
I don't know why the appellant drove in this manner. All I know is when that vehicle approached him, he had 20 seconds to do the right thing, which is merge back into his own lane.
Isn't the fact that he wasn't paying attention, or at least the inference can be that he simply wasn't paying attention, isn't that a significant distinction between this case and the DePriest case where he remained in the wrong lane? That remaining in the wrong lane was specifically found to be calculated and willful. Isn't distracted driving different than calculated and willful?
You'd have to assume that he didn't see the vehicle right in front of him with the lights on a clear day, on a flat, straight road, with a vehicle by him, honking desperately, trying to
Well, counsel,
get him to
I don't know
pay
that this is dispositive, but doesn't all that evidence raise an inference that the driver was maybe incredibly careless and distracted? Gets over at the very last second.
Well, it was certainly an indifference to the consequences of his actions. The way he was driving was likely to cause the death or great bodily harm of another at that point. Focusing on the last 20 seconds, the victim, makes a last-ditch effort to save her life.
Let's ask you
by
this
pulling
way:
into
could the jury
oncoming-
have concluded that the driver, the appellant, was distracted, and therefore that this was not reckless driving? It was negligent driving. Could the jury have concluded that?
It's a jury question then.
Well, so yeah, so your answer is yes. There was evidence from which.
Intent is a jury question.
Well, there was evidence from which the jury could have concluded this was careless instead of reckless.
Yes.
Yes.
However-
Hold on. Was there evidence from which the jury could have concluded that this was reckless instead, and that the driver wasn't merely distracted?
Yes, his actions, Your Honor. The fact that he had all sorts of options available to alleviate the dangerous situation he had created, and he did not take advantage of them. He did not merge back into his proper lane.
The other witnesses said that he had room to get back over, and he didn't, right?
Correct.
Is that an inference that he was driving recklessly? Could the jury have concluded that he was driving?
Yes, he could have braked and gotten back behind Mrs. Bellis. He didn't do that either. But when he sees an oncoming vehicle, or if an oncoming vehicle is in his lane where there's no reason for him not to have seen it, and he continues to drive in that lane, that is action certainly likely to cause great bodily harm or death.
He tried to avoid the vehicle at the last second in this case, and that didn't happen in DePriest, right?
She avoided him. The victim in this case did.
That's not what I asked you.
I apologize.
He took an action
Yes.
to try to avoid that other car. It didn't work out because she took the similar
Boy,
action.
did it not work out. Yeah, had he just
Isn't
stayed in the
that-
westbound lane, the
But that's a
accident would not have
distinction, another
happened.
distinction between the facts of our case and DePriest. In DePriest, he just kept going straight and never took any action to avoid the car.
Yes, that's correct.
Is that another inference that maybe he wasn't paying attention? All of a sudden, he said, "Oh my God, I haven't been paying attention. I better get out of this guy's way."
I think taking all the evidence in the light most favorable to the state, his actions were inexplicable and likely to cause death or great bodily harm. There's one last point I feel like I need to make. the victim moved into oncoming traffic lane to try to avoid the head-on collision that she was facing. She got in that other lane first. And inexplicably, the appellant then does the same thing. And that's exactly where the accident or the collision occurred. But he then makes another inexplicable choice to move into the lane, ending up causing the head-on collision that she had just so desperately tried to avoid.
Counsel, I mean, it is a sort of an striking fact in this case that the testimony was that the victim swerved into oncoming traffic 2 seconds before he then swerved into the same lane. It is strange that, right, it's sort of unique or maybe important here that the appellant swerved after the victim did. So
Yes.
What inferences are we to draw from that? I mean, is there an inference that is actually evidence that he was just distracted and suddenly realized what was happening?
I just think it's more evidence of reckless driving. The vehicle in front of him was no longer there, and yet he moves into the same vehicle that she had just moved into trying to save her life.
Well, but I mean, unlike in DePriest, I mean, someone who's riding in that lane for convenience wouldn't intentionally swerve over into another lane where the other car has already swerved, right? So,
Well, in DePriest, he said he was there so he didn't have to go, back and forth between the lanes. I'm sure in DePriest's mind, if he met oncoming traffic, he knew he had a duty to get out of the way. There's 3 separate areas of analysis in this case. It's the first area where it's 30 to 40 seconds of him just hanging out over there after he passed, hanging out for no good reason. Again, inexplicable, but people do inexplicable things sometime. And the fact that he didn't explain it to us, it is of no relevance, in my opinion, because his actions speak for himself.
Counsel, how was the photograph at all relevant to the state's case?
Well, the
Or should we
judge
go
let
to
it-
the harmless error analysis?
I'm sorry, sir?
Or do you just want to talk about harmless error?
I would prefer to go to the harmless error analysis, yes, sir. It is my understanding that the single black and white photo of all the photos, including there were several autopsy photos that the trial judge kept out, and they were color, that the single black and white photo of the victim's remains came in. Several other witnesses had already testified that the victim's body, the car was on fire and the victim's body had burnt up. It was information that was already out there in the jury's knowledge.
It didn't seem like the photograph, from my review of the record, it didn't seem like the photograph was focused on at all. It
Correct.
wasn't emphasized in
That's
closing or anything like that.
Correct. It was a minuscule part of the state's case. I believe the state focused on the defendant's driving. There was never...
Here's something that always drives me crazy. The state spent pages and pages of the transcript fighting to get these photographs in, how critical they are to the state's case in chief, including this photograph. If it was improperly admitted, now you come in and say, oh, well, it's harmless. It wasn't that big a deal anyway. The jury couldn't have paid any attention to it. If that's the case, why fight so hard to get in something like this? And then turn around and say it's harmless.
It was just one photo, Your Honor. It was just one photo. I certainly understand
Counsel, I mean,
your question.
let's go to the other issue, right? And from our record, which is all we have, that's all we can look at.
Yes, sir.
I cannot tell what that photograph is.
Yeah, I had
Even
the
once you
same
tell
trouble.
me, even once I read in the record, this is what this photograph is of, I still can't see it. It looks like a really bad photocopy with just a dark spot on the page to me.
I agree, Your Honor. It doesn't have that kind of gruesomeness that other autopsy photographs or crime scene photographs typically have, where they are not admitted because the prejudicial value outweighs the probative value. And we would argue that it was harmless. It was a minuscule part of the state's case. The jury was already very aware that this victim's body burned up in the vehicle. As to the third point,
You can confirm that our photograph is obviously black and white.
Yes.
That's what the jury was shown, a black and white photograph.
That's my understanding as well, Your Honor.
Yeah, that's what it looks like.
As to point 3, we'd rely on the arguments made in our brief, and we'd request that you would affirm in all respects. Thank you.
Thank you, counsel. All right, counsel, you have 16 seconds.
May it please the court, this was not recklessness, it was careless or negligent driving at most. Regarding the photo, the state wanted it in for a reason. If there's any question about the photo you're looking at being the actual photo, I will immediately file a motion to supplement so this court has the actual photo so you can look at it. They wanted it in for a reason. Because this was so close, that's exactly why it's not harmless in this case. Thank you.
Thank you, counsel.